It was another judgment day for the judges. However, the Judges and Magistrates Vetting Board said time was not ripe yet to declare Justices Kalpana Rawal, Martha Kome and David Maraga either suitable or unsuitable to continue serving in the judiciary. This is why.
The three judges are members of the court, which is yet to determine the appeal in regard to the election date.
Other judges, however, have known their fate. It was a close call for Supreme Court Judge Jackton Ojwang, who, like his two other counterparts, was fighting complaints of delaying judgment and thereby undermining justice. The board heard that he had cases, some pending for up to 1 year. However, he dispensed with all of them this year, and by the time the interviews began in February, he had no case pending.
One delicately probed about a rumor that he might have employed outside lawyers to assist him in writing the judgments. He responded with what appeared to be genuine emotion, that the decisions were very much those of the judge alone.
It wasn't the same for his counterpart, Justice Mohammed Ibrahim. Ibrahim admitted to the vetting board that he had been in great default. There are some cases that are still awaiting his judgment 9 years on.
The judge appended two further sets of documents. The first set included a copy of a letter he sent on the 2nd of May 2012 to the Honorable the Chief Justice, requiring that he be released for 3 months to enable him to deal with the 264 matters where the judgments and rulings were still pending.
The script was the same for appellate judge Lady Justice Roselyn Nambuye. Only her judgments did not delay for 9 years, but between 4 months and 1 year. Indeed, by the time the vetting board began its work, Nambuye had 14 cases pending.
The judge is fluent and articulate. However, her writing style and inefficiency in the drafting and delivery of judgments added to the backlog. The board was made aware of one judgment running to over 300 pages.
The board observed that delivering judgments was the core function of the judges. It's neither a favor nor privilege. Therefore, those who dragged their feet were guilty of delaying justice, which the board says undermined the delivery of justice.
The delays were unacceptable, carried like a hump on a camel's back from one posting to the next. Literally, hundreds of litigants from every walk of life felt robbed of their right to have their cases fully and finally determined.
To disqualify a judge, the board has been looking out for corruption, bias, especially when dealing with high-profile cases, and thirdly, delay in providing justice.
Factors to be taken into account include the length of the delay, the volume of delayed decisions, the urgency of the matters to be decided, the particular systemic pressures faced by the judge sitting at a particular station, personal factors such as ill health or bereavement, and the steps taken by the judge to audit, manage, and eliminate the backlog.
As for the 4 appellate judges who had been declared unsuitable earlier on, the board observed that it had not made any error of law in dismissing them in the first instance.
If there is an error, it lies in the description of the board's findings, not in the findings themselves.
Justice Samuel Bosire, for example, terminated the infamous Goldenberg inquiry without summoning senior government officials to testify, thereby defying a court order.
The finding that the judge defied a court order was, however, only one of 2 matters of deep concern to the board in its determination. The second was the reasoning advanced by the judge in support of this defiance of a court order.
According to the board, Justices Bosire, Nyamu, Okubasu and Omollo's conduct damaged the public's confidence in the judiciary. Rao described the damage as indomitable, extensive and irremediable. The fate of the 4 judges is now sealed. Sylvia Chebet, Citizen Weekend.